States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1024, Louisiana Public Service Commission petitioner versus Federal Energy Regulatory Commission. Mr. Fontham for the petitioner, Ms. Perry for the respondent.
Mr. Fontham, good morning.
Good morning.
Please proceed.
May it please the court, my name is Mike Fontham. I represent the Louisiana Public Service Commission. In this case, FERC, relying on 6 words of a 2009 tariff amendment and applying it to a 2005 regulatory decision, excluded approximately $30 million of legitimate production costs paid by Louisiana ratepayers from the energy bandwidth tariff. I'm going to argue 2 points. The first point is that FERC incorrectly interpreted the tariff by relying on a single subordinate clause without considering or addressing the words of the entire tariff amendment or the settlement that the tariff amendment was filed in compliance with, or the filing letter, which said that the tariff amendment would only apply to deferrals going forward. And secondly, that FERC's action applying a 2009 amendment to the effects of a regulatory decision made when no one could ever possibly know that the amendment was going to be filed 4 years later is improper retroactive rate making. I would like to make 3 or 4 points about the facts, and then I will address those 2 points of argument. First of all, I know the members of this court may not be familiar with the energy bandwidth tariff, but it was adopted in 2005 in order to eliminate undue discrimination on the energy system. The rough part of rough equalization is plus or minus 11%. Anything beyond plus or minus 11% is unduly discriminatory. The bandwidth tariff was adopted to rely on the books and records of the energy operating companies. In other words, what went onto the books went into the tariff. And FERC has always required that the accounting be consistent with FERC requirements. And on many occasions, FERC has overruled accounting errors made by energy. There was an accounting error in this case. It affects deferrals, which bring about credits and debits, which basically do this. A utility has a big cost, it wants to spread it out. So what happens is there will be a credit on the books in the year those big costs arrive at the utility. But the Regulatory Commission allows the utility to defer that. So the credit happens to take the cost off the books. Then those costs are charged to ratepayers later and amortized on the books later. So 100% are captured. They're just captured with different timing. The correct accounting for a deferral, as held by FERC in this case, is that you recognize that costs are deferred and take them off the books. That takes them off and out of the bandwidth. You then recognize later when the ratepayers pay the costs that the costs are being amortized. You add them to the expenses in the books. That puts them back into the bandwidth. In this case, because energy was engaging, as I said, in improper accounting and then changed the accounting, and there are 5 different operating companies, there was concern about the consistency of the practices. So an amendment, a tariff amendment, was adopted in 2009, 4 years after this deferral. And that tariff amendment said that it would exclude from the bandwidth what was on the accounting books. So effectively, the costs would count in 2009, and in later years, they would not count. But that change was made, as I said, 4 years after 2005. The 2005 case, unfortunately, was delayed. The court overruled that delay. The case did not go to hearing until 2016, 11 years after the 2005 costs were incurred. And so FERC had a hearing and had to make a determination about a 2005 credit and the debits associated with it. FERC decided, relying on 6 words in the tariff amendment, which said, or the amortization of previously deferred costs, that the tariff amendment could take out the debits even while it recognized the credit that had occurred in 2005. And that's what we're appealing. Our first point of argument is that the FERC arbitrarily interpreted the tariff amendment. The tariff amendment makes clear, we believe, that it could only apply to new deferrals and the effects of new deferrals going forward. The tariff amendment, which is quoted on page 8 of our brief, says, excluding the effects, plural, debits and credits, plural, resulting from a regulatory decision, singular. A regulatory decision has 2 effects. First, there's a credit. A regulatory deferral decision has 2 effects. First, there's a deferral and a credit, and then there are amortizations and the costs are counted. Those are debits. And this says it's going to apply to the effects, both effects of a regulatory decision. And then it says that causes the deferral of the recovery of current year costs. That's what happens first, or the amortization of previously deferred costs. That's what happens after that. And that's what happened in this case. You cannot simply focus.
The amendment seems keyed to the debits and the credits, though, not keyed to the decision, the prior regulatory decision. It says exclude from PERP, which is the relevant account here, debits and credits resulting from a prior decision. So if this were just, if the construction of this clause were governed by ordinary principles of retroactivity law, it would cover future debits and credits resulting from a past decision, because what's excluded are the debits and the credits. Why shouldn't we read it that way?
Well, you shouldn't read it that way because it encompasses both. FERC applied it to encompass one. FERC applied it to encompass the amortization of previously deferred costs and not the credit, which occurred in 2005. And the only way, and this is what was trying to get through, is to encompass debits and credits, both. You have to only apply it going forward because the credit occurs first. Okay, this credit had occurred in the past, just like you say, applying normal principles of retroactivity. You can't apply this to the past. But that's what they did. Well, what they actually did is they didn't apply it to the past credit. They did apply it to the amortization starting in 2009 and going forward. So they separated it. And you cannot interpret the amendment to apply to half of something done previously and not apply to the rest of it. FERC said it would be retroactive rate making to apply it to the credit, and the debits are effects of that credit, that very same credit. And the only way you can interpret that is, okay, it's going to apply to new deferrals. Now, the second point is we had a settlement agreement. And the settlement agreement, nobody contests this. The settlement agreement makes it absolutely clear that this is only going to apply to 2009 deferrals and going forward. No past deferrals. This is not contested in any of the briefs. They say, well, that's extrinsic evidence. But the settlement agreement was a contract among all the parties, agreed to by all the parties, filed with FERC and approved by FERC. And it is the agreement under which this tariff amendment was filed to comply with the settlement.
Mr. Fontham,
And
if amortization that typically follows a deferral is understood as part of the same regulatory decision as the deferral, I'm just wondering why the text of this amendment separately mentions the amortization.
because, Your Honor, if one is going to occur in one year and the other is going to occur in the other year. So you'll have like in this case, we had a deferral that had a credit in 2005. Now, there were no amortizations in 2005. The amortizations occurred in the later years, 2006, 7, 8, and 9. And the way a regulatory decision works, because of retroactive rate making, you have to give them approval in advance to defer the cost and collect it later, because the cost, otherwise would have been recognized in 2005. So any decision that allows a deferral is effectively a guarantee of sorts that they're going to be able to collect it later. That's the only way they can book it. And so they are inextricably intertwined.
And is that two separate regulatory decisions? It's typically one, no? Or it's two separate
Yes.
because the deferral decision is made at one time, and then as you're going forward and approving later rates, the amortization approval is granted?
Well, the way it works, Your Honor, is that the single decision legitimizes both. Now, there
Okay.
might be a later rate case that simply applies the prior deferral decision to say, okay, you can collect this, even though
But it was approved as a deferral. So in your reading, the last dozen or so words are really unnecessary. Effects, debits, and credits resulting from a regulatory decision, period. This is, I think, along the same lines as Judge Katsas's question. If the real sort of decisive point for purposes of prospectivity or retroactivity is the regulatory decision, then the separate reference to causing the deferral of the recovery of current year costs or the amortization of previously deferred costs, those aren't really two separate things in your view? Is that?
Well, Your Honor, I think the way these things work, there's lots of things that can cause debits and credits from a regulatory decision.
Okay.
This was making it clear that it was a deferral of costs. These were purchase power costs.
Yeah.
And so I just think it's being more complete.
So are there
that they go
situations
to-
as a practical matter in which a state regulatory agency issues a deferral without subsequent amortization or with only
They
partial
can't.
amortization in practice?
Utility would never accept that because they may be stuck not recovering the costs.
So
So
as it
that
works
if
in
they're gonna-
practice, is it the case in your experience that deferrals and amortizations aren't really distinct regulatory decisions or actions?
Well, they come from the same decision, and so they're not distinct in that sense because it's one package of costs. But clearly, one is a credit, one is a debit, and it's going to add to the costs in one year, and it's going to take off of the costs in the first year.
Right, but it sounds like the gravamen of your position is that so goes the one, also goes the other, and that what's happened here is there's been, the credit was treated under the pre-settlement agreement regime, and then the amortizations under the settlement agreement, and that just, it bisects these things that actually go together.
That's exactly right, Your Honor.
So you have a pair of
But,
shoes
you know,
and you can't wear either one of them because they're no longer available in the same world.
that's true. I think that's the only way you can interpret this amendment. But I do want to emphasize the settlement agreement is just as much a contract affecting rates as the tariff is. Energy followed the settlement agreement to apply the other provisions of the tariff. It was approved by FERC. It's a contract, and Boston Edison, the ruling of principle in Boston Edison makes it absolutely clear that you can't pull out the words in the formula and take it away from the contract that called for the words in the formula. And the settlement agreement, no one disagrees. The settlement agreement only deferrals going forward, as the filing letter said. The filing letter, sorry,
can I ask one more question, which is, what you say makes a lot of intuitive sense, but I assume it must be fairly common in situations when you're accounting for these capital expenses or prepaid costs, whatever it is, you have to account for a transaction that takes place over many accounting periods. And the accounting rules change in the middle of that time stream. I assume it's fairly common that the change can be applied to the remaining part of that transaction. I mean, you make a capital expense when you you buy equipment when the law says you can depreciate it over 30 years, and then 10 years later the rules change and you have to depreciate it over 40 years or whatever, and that change applies to that transaction, even though on the front end it was made under different rules. So isn't this just a variation on that?
No, Your Honor, it's not, because you're right about the accounting rules changing, but this wasn't a change in the accounting rules. The accounting rules are still the same that they were, in day one. And one thing about a deferral.
Sorry, it's a contractual equivalent of that, because the parties under the filed rate doctrine can make these decisions for themselves, and they're saying they want this transition to work in that way.
Yes, to new deferrals. That's what they said. That's what they agreed on. That's what the settlement said. And that's what the filing letter said. And that's really what the tariff amendment itself says. But this was a change to the tariff and what would go into the bandwidth. The accounting never changed. All these costs were being paid by Louisiana ratepayers. And if you're talking about a deferral, you can change the timing. You cannot change the fact that the costs do get recovered, no matter what you do with the accounting rules. That's just part of the ability of the utility to book it in the first place.
Right.
So I see my time's run out. I hope I get 1 minute or something for rebuttal, but
Sure, if there are no more questions.
Let me just ask you one more question, Mr. Fontham. What do you make of the or? I mean, it seems in the text, or the recovery of current year costs or the amortization. It seems like your reading really is viewing that as an and.
No, that's not our reading, Your Honor. Our reading is that it says or, because only one of the two things will occur in any particular year.
Mm-hmm. Okay.
All right. We'll now hear from Ms. Perry.
May it please the court, Lona Perry for the commission. The commission, in interpreting the PERC variable in the bandwidth tariff, concluded that there was no other way to read that per variable other than to read it as excluding from the bandwidth tariff as of 2009 the amortization of previously deferred costs. And the Louisiana's position that it only applies to the deferral of the recovery of current year costs completely excludes everything following the OR, which because this was enacted in 2009 and was effective as of the calculations for the bandwidth tariff in 2009, that phrase necessarily excluded current amortizations booked in 2008 and part of the 2009 calculations that resulted from the 2005 deferral of costs.
It isn't the strong background rule and assumption in myriad contexts, and that a credit goes together with the amortization, that the deferral, that these are really two steps of one process. And in fact, I mean, it seems like there's no argument that this isn't quite disadvantageous to LPSC.
It does, Your Honor, result in the exclusion of those amortization debits from the bandwidth tariff. But there is no other way to read that language. That language specifically separates the deferral of the recovery of current year costs and the amortization of previously deferred costs.
Well,
and
Mr. Fontaine, I'm sorry, go ahead.
I'm sorry. I'm just saying with the or in the section, what the section says, if either one of those are excluded, both of them don't have to be excluded. Either one of those are excluded. And here we had current amortization of previously deferred costs, and the commission saw no other way to read that provision other than to require the exclusion of those costs.
Why not read it so that the relevant retroactivity event is the regulatory decision? The amendment covers future regulatory decisions and ensuing debits, credits, deferrals, amortizations.
Because, Your Honor, the provision excludes the effects that result from a regulatory decision, and the effects are debits and credits, such that it causes either the deferral or the recovery of current year costs or the amortization of previously deferred costs. And here we had the effect of the 2005 regulatory decision that caused the amortization of previously deferred costs in 2009.
I assume there's some interpretive principle that you construe tariff amendments, if at all possible, to be consistent with energy law. Shouldn't there be a similar interpretive principle to construe tariff amendments, if at all possible, to be consistent with ordinary accounting rules and understandings?
Your Honor, the commission did not find this provision to be susceptible of the contrary interpretation. And in the filed rate context, the filed rate is paramount. And you can see this in all of the prior bandwidth proceedings. In every case, Louisiana has had a problem with the function of one of the provisions in the bandwidth tariff. And in every case, this court or the Fifth Circuit has said the filed rate is the filed rate. And if it is inequitable, it's a function of the filed rate doctrine.
I understand that, and clearly you have a plausible, if not very strong, textual argument, which you've laid out quite capably, but it does produce very strange accounting, right? I mean, suppose take this out of the bandwidth context and just imagine that you all are regulating how an electric company can recover its capital costs. I mean, it would be irrational to say when an investment is made, the cost can't be immediately recovered because it has to be spread out over time. And then in the middle of that time to say, well, you know what, we're changing the rule. We now think that the cost can be recovered right away, but we're not going to let you recover the outstanding amount of that investment. I mean, I can't think of any reason why a regulator would ever do that for a category of expenses here that everyone concedes are legitimate. And in the abstract, the company should be able to recover for. I mean, why would anyone ever do it that way?
Your Honor, nobody is suggesting that it was done that way on purpose with regard to this particular deferral, because this particular deferral was not at issue at the time that this contract, that this tariff provision was entered into. But the thing you have to remember is that unanticipated consequences often arise in filed rate doctrine cases. It usually arises because some unanticipated event occurs and the tariff language applies in some way that wasn't expected, but it nevertheless is the filed rate and it has to be enforced as it is written. And it can be changed in advance, prospectively, either by the utility filing under 205 or by somebody filing a complaint under 206. But this court has been very clear that once it is the filed rate, and this has been the filed rate in a final approved order since 2009, that it cannot be changed. It cannot be changed for equitable reasons. And this is what the court said in Old Dominion, that even though they had unanticipated consequences from the polar vortex that resulted in generators having to take great losses to generate power, it was nevertheless, there was a rate cap and it was the filed rate and there was nothing that could be done about that.
Ms. Perry, you've taken the position, I think, quite clearly in the brief and also today that FERC believes that the challenge orders are unambiguous. And so if we were to find any ambiguity, then we would have to remand, right?
I believe that's right, Your Honor. I believe the law is that the commission must then be given an opportunity to interpret the ambiguity if the court finds there is an ambiguity.
And in terms of what we look to determine whether it's impermissibly retroactive or not, is it the regulatory determination? Or in your view, it's the amortization itself?
It is it's the effect. What is excluded under the PERC variable is it excludes the effect, which is either the deferral or the amortization. And the amortization is not retroactive because the amortization is booked in the current year. And so we are excluding a cost that is being booked in the current year. So it's not a retroactive.
But the bandwidth calculation, so it became effective in 2009 and it applied to the 2008 bandwidth calculation. And in your view, that's not retroactive because it's just referring to cost data and not charging?
Your Honor,
retrospectively?
The bandwidth every year applies to the prior year costs.
Right.
And nobody has ever found that to be retroactive rate making. And I would make the point also that the fact that this 2009 tariff was going to apply to the 2008 costs was decided back in the tariff order, which is at the Joint Appendix 1357 to 1358. In that order, the Commission expressly granted Entergy's request that the amendment be effective May 31st, 2009, so that it would apply to the bandwidth calculations in 2009, which are based on 2008 costs. So it has been that is part of the filed rate here, and that is settled in a 2009 order that is a final order that was never appealed. To the contrary, as the commission pointed out, Louisiana supported the filing and supported the issuance of this order, accepting Entergy's tariff filing. So the fact that it applies appropriately to the 2008 costs has been decided since 2009, and that's not before the court now. That is no longer an issue. It's
so the question of how petitioners, you rely heavily on the last part of the of the disputed language, and they rely pretty substantially on debits and credits, which would seem to pair the two. And your response to that is no ambiguity because
debits and credits, it defines what effects means. Effects are debits and credits. But what the provision goes on to say is that it excludes the effects, debits and credits, resulting from a regulatory decision that causes either the deferral of the recovery of current year costs or the amortization of previously deferred costs. And the provision separates the two if it causes either one or the other, recognizing that they happen in different years.
But a regulatory decision is the I mean, and this is, again, Judge Katsas' first question to Mr. Fontham, if the focus for purposes of prospectivity is a regulatory decision, then if the regulatory decision has only debits and no credits, or only credits and no debits, fine, then you have the or in the last part of the language decoupling them. But where you have one regulatory decision that has both debits and credits, why is the clearest reading of the language not that it either applies to the debits and credits or it doesn't apply to either?
Your Honor, as Mr. Fontham was explaining earlier, the debits and credits, for these deferrals, you have to have both, because one takes away and one gives back.
Exactly.
They happen in different years. And that is why there's an or, is because in any given year, it'll be one or the other, but it won't be both. And so in any given year, you're applying either the new deferral or you're looking at the amortization of previously deferred costs,
exactly.
but not both. Both.
Exactly.
And so
you and he agree on the or, but the question then is, was this language meant in terms of the first application to sever the one half of a regulatory effect from the other?
Your Honor,
which seems like there's as a matter of just sort of background accounting and FERC practice, I haven't seen a case. I mean, I understand that there are anomalies, as you were pointing out, from weather conditions or things that make a rate disadvantageous once it is ultimately paid. But I haven't seen another situation in which deferral and amortization decisions were severed in this way. Is that something that is more familiar to you than I'm aware of?
Well, I'm not aware that this comes up very often. The bandwidth tariff, because it compares production cost, has many aspects to it that are unique in the world of tariffs. This isn't a common situation that you would be in the position of trying to decide what goes into a tariff that compares production costs. And it's not that nobody is suggesting that at the time they wrote this language, they had this situation in mind. But the problem is that now that we are here, the commission could not see a way that the amortization of previously deferred costs would not exclude the amortization of the previously deferred costs from 2005, because that seems to exactly address the situation, even though it wasn't probably in anybody's mind at the time. It was, but the way it is written, it seems to directly address the situation. I see I'm out of time. If there are no further questions.
All right. Do my colleagues have any more questions?
No, thank you.
Okay.
Thank
Then
you.
Thank you. Mr. Fontham, why don't you take 2 minutes?
Thank you, Your Honor. I'd like to address the question Judge Katsas raised, and I think it also goes to what Judge Pillard asked about. Your Honor, if a utility got a deferral and the commission tried to change the rules in the middle of the stream during the amortizations, that would be unlawful, retroactive rate making. It does not happen. You have granted a deferral in which the implicit rule is you're going to be able to collect it over X number of years. That's required by the accounting rules, and that's basically in the deferrals we've granted, we have to specify how they're going to be collected. You try to change the rules, it's retroactive rate making. And that goes to Judge Pillard's point. The focus is on the decision. It has to be on the decision because the decision is what creates two things, a credit and subsequent debits, a deferral and subsequent amortizations. You can't focus on one without covering the other, which means it has to be a going forward amendment applicable to new deferrals and subsequent amortizations. And thirdly, everybody agrees that the intent of this amendment was only to apply to deferrals going forward and their effects. Everybody agrees with that. Now they say, well, the language doesn't say that, but that is what everyone agrees, every witness at the hearing, the settlement, the filing letter. Energy proposes that this apply to deferrals going forward in 2009. They constructed this to evade that. So that's my argument, and appreciate the rebuttal time.
All right. Thank you, counsel. Your case is submitted.
Case number 20-5026, Genus Medical Technologies LLC versus United States Food and Drug Administration, appellants. Mr. Winnick for the appellant, Mr. Farquhar for the appellate.
Mr. Winnick, good morning. Please proceed.
Good morning, Your Honor. May it please the court, Daniel Winnick for the FDA. The product at issue here falls within the text of the drug definition in the Food, Drug, and Cosmetic Act. And the FDA has consistently treated such products as drugs for 23 years. Yet the district court concluded that Congress unambiguously foreclosed the FDA's discretion to treat this product as a drug. That was incorrect for two reasons, one that applies to the FDA's regulation of all products, and one that applies specifically to its regulation of contrast agents. Let me start with the broad reason. The district court's rationale was that because the statutory device definition is narrower than the drug definition, it must be read, it can only be read, as impliedly limiting the drug definition. But that assumes Congress could only have meant for the drug and device definitions to be mutually exclusive. And in fact, there's no reason to believe that. The statute used to contain language excluding devices from the drug definition, but Congress removed that language 30 years ago. The current text of the drug definition plainly encompasses the device definition, and the statutory structure and purpose provide no basis to read into the drug definition a limitation not supplied by its text. The canons invoked by the district court require either conflicting statutory provisions or superfluity, and here there is neither under the FDA's interpretation. So it's consistent with the statute's two-track regulatory scheme for the FDA to decide which of the two pathways to apply to a product that satisfies both definitions.
Can we talk about?
Mr. Win.
Go ahead, Judge Henderson. Sorry.
Okay, I was just going to ask. Your letter says that it appears that this silk solution is a device. I have a hard time seeing how it's a device. I realize that that's not an issue that you all have raised, but there is plenty of precedent for us to consider an issue antecedent to, and this is, I'm looking now at the Supreme Court's case in 1992, the U.S. National Bank versus Independent Insurance Agents. A court may consider an issue antecedent to and ultimately dispositive of the dispute for it, even if the parties fail to identify and brief the issue. And as I say, I just have a hard time seeing that this oral solution is a device. What does it fall under? It's not an instrument. It's not an implement, a machine, an implant, or in vitro reaction. It's not even an apparatus or a contrivance, what that is, whatever that means. And you're left with an article. And I realize that every drug is defined in terms of being an article.
So let me address the question first and then speak to its relevance to this case. The clause Your Honor just read, the sort of prefatory clause of the device definition, has been read differently at sort of various times. The FDA's current view, expressed in its guidance, is that that language doesn't play much of a limiting role, and the reason, frankly, is that there's just such a broad diversity of products that many things that you wouldn't think of as a machine, contrivance, etc., are properly classed as devices. So, for example, an example given in the FDA's guidance is a solution that is used to clean, surgical instruments or something like that. Could be a device, even though you wouldn't think of it as a contrivance, implant, etc. And the FDA has sort of moved past the view it might have held at certain times in the past that language refers to devices as "quote unquote" things that go clank. So the FDA's view, the FDA didn't pass on this question here. It didn't specifically find that this was a device. It merely said, as Your Honor noted, that even if it is a device, the agency would choose to regulate it as a drug. I don't think under the Chenery Doctrine it would be open to the court to reverse on the ground that actually this is a device, since that wasn't the issue passed on by the agency. But I would say, as to what,
don't we run into the threat of an advisory opinion if we say, well, we'll make the same assumption that this is both a device and a drug, when at least I think it doesn't qualify as a device to begin with. And so, in other words, the question before us is, does the FDA have the discretion, when it's both a device and a drug, to treat it as a drug? And my question to you is, before we even get to your discretion, it's not a device.
So without being able to state definitively how the FDA would address the question, is it a device? I can say that the FDA is highly skeptical of the conclusion that this product doesn't fit the device definition. The FDA regards it's
wait,
not.
There were a bunch of negatives in there.
Yes,
what
I'm
is
sorry.
the FDA?
The FDA, if the court were, for example, to remand for the FDA to specifically pass on whether this is a device, I think it's highly likely that the FDA would conclude that this is a device. In other words, I don't think
this is a device.
That this does fit the device definition.
And I had the same question to some extent as Judge Henderson, and the best I could do was to think that this is an accessory to a CT scan or an X-ray, that the barium is part of what sets up the scanning technology to actually function. And so it could be plausibly a device, but it also led me to be somewhat surprised by the FDA's position that the drug definition wholly subsumes the device definition, because it seemed to me with some of the other references in the prefatory phrase of the definition of device there are going to be implements, machines, apparati that, because they are so clearly those things, would be devices and would not be drugs. And that in that, in setting aside the district court's application and the appellee's application of the specific predominating over the general with respect to the exclusion, with respect to the definition of a device, it seems to me more plausible and more straightforward that what is more narrowly explicated in the device definition might in fact bring things, be decisive of the categorization for at least a number of devices. But that's not the FDA's position.
It is not the FDA's position, and I do think as a textual matter, the relevant word in the drug definition is articles, and the device definition does specify a narrower subset, an instrument, apparatus, etc., or other similar or related article, but that is a subset of articles. And so we'd return to our broader position here, which is that there is no basis to read the device definition as impliedly limiting the broader drug definition,
right?
Unless reading, unless declining to do so creates either an irreconcilable conflict or superfluity, which is what the district court believed, and that's simply incorrect.
So on your understanding, all devices are drugs, correct?
Correct, Your Honor.
And so then let's talk about statutory structure. Statutory structure, as I understand it, is all drugs must go through a very elaborate approval process under one part of the statute that's done by one part of FDA. And all devices have to go through a very different approval process that's done by a different part of FDA. And nobody thinks that some particular article should have to go on both tracks, correct?
That's correct, Your Honor. Everybody agrees that the FDA has to identify whether to treat the product as a drug or a device, and that's commonplace under the FDCA.
So the statutory structure is if drug, then you're on track 1, but not track 2. If device, you're on track 2, but not track 1. And the device circle is wholly within the drug circle. And yet you acknowledge that this can't be rationally read to require both. And then you treat the statutory structure, which says the definition has all of these mandatory consequences associated with that product. You read that as saying, well, no, the FDA, in fact, has unfettered choice to pick whether to treat something as one as opposed to the other.
So I disagree in a couple of ways, Your Honor. First, I don't think any of the mandatory consequences Your Honor referenced follow from the fact that something falls within the broad drug definition. I think it follows from the FDA's decision that it is to be regulated as a drug as opposed to a device. And again, there's lots of...
You don't think the statute is self-executing in saying that no drug may be marketed without FDA approval?
I think if something satisfies both the definition of a drug and the definition of a device, and the FDA exercising the role Congress gave it under Section 360 BBB2 determines that the product is to be regulated as a device, I don't think under the statute the drug requirements apply.
So if something were a cosmetic and also a drug, the FDA would have discretion to put it through the much lighter preclearance of or approval process of a cosmetic.
I believe that's true, Your Honor, and it is a great example of the sorts of overlaps that happen all the time under the FDCA. It's not just in the drug device context. There's also, of course, biologics as well. So it is commonplace in this regulatory scheme for products to fall within, multiple broad, regulatory headings, and for the FDA exercising discretion given to it by Congress to decide which pathway to apply.
So everything that's a tobacco product everything that's a modified risk tobacco product is also a tobacco product, kind of by definition. So if the FDA wanted to, it could just ignore the modified risk tobacco product, more demanding pathway, and treat all modified risk tobacco products as just ordinary tobacco products. It seems quite surprising to me.
So we don't think, in the context of this case, we don't think it would be remotely open to the FDA to say that it is going to treat as a drug every product that satisfies the device definition. And this goes to the second part of Judge Katsas' question, which is the FDA's discretion here unfettered? It isn't remotely unfettered. I mean, if the FDA did that, it would clearly be contrary to Congress's decision to create two pathways. What the FDA has done is exercise that discretion in a very limited number of cases, which is why the issue hasn't arisen to this court in 30 years since the 1990 amendment.
But the question is what you can do under your interpretive theory. And if on the Venn diagram, if the circle for devices is entirely within the larger circle for drugs, and your theory is that any article that satisfies both, which is everything in the smaller circle, you have discretion to treat as either. What follows from that is you have discretion to treat every device as a drug, and that just makes nonsense out of the statutory structure, which is one reticulated scheme for drugs and another for devices.
But with respect, Your Honor, we don't think we have discretion to do that. If FDA treated as a drug every product that satisfies the device definition, it would clearly be contrary to Congress's decision to create two statutory schemes.
Right, and that's really Mr. Farquhar's view. And I guess, to me, maybe we should move to the argument that's actually made, which is not about the predicate clause in the medical device definition, but about the exclusion. It seems to me there, even if you were more receptive to the questions that we've been asking about the predicate clause, that it in fact specifies some category of things that are devices that don't also fall within the drug definition because of the operation of their additional specificity. So because of the operation of the canon that the specific governs the general. Even if you accept that, then it seems to me that the district court applied the same reasoning to the exclusionary clause, and I'm not sure that it necessarily follows. So the exclusionary clause is excluding roughly things that are metabolized or function through a chemical reaction, and it says those are not devices. And as I understand it, what the district court did was say, okay, if they're not devices, that means they're drugs, and that means that something that is not, that means that is part of the drug definition, and something that does not fall within that exclusion, therefore necessarily is not a drug. And those further implications seem to me not necessarily to follow from the canon that the specific governs the general. And I just wonder, and let me just add one more thing that might make that clearer. So the fact that it's not a device might imply that it's a biological, or that it is food, not that it is necessarily a drug, because it's a multipolar statute, not a bipolar statute. And I guess I'm just wondering whether you agree with that. It's a narrower way to look at your position than the one you've marked out, where all devices are also drugs.
So under our view, if a product if a product falls within the exclusionary clauses of the device definition, but otherwise satisfies the device definition, it is a drug, because we regard the drug definition as encompassing the device definition. Now, biologics are also drugs under the statute, which is, again, another example of an overlap that is just ubiquitous in the FECA, and why it's not so strange to have overlapping regulatory categories. We agree, of course, that the district court was incorrect to apply the specific governs the general canon, but I think we take that view for a somewhat different reason, which is that Under this court's decisions and the Supreme Court's decisions, that canon applies in two and only two scenarios. One is where there would otherwise be irreconcilable conflict in the statute. So, one provision says no vehicles in the park, another says bicycles can go in the park, right? That's a classic example. The other is where you have a broad provision and a specific provision applying side by side, so that reading the broad provision as applicable would read out of the statute the specific provision. So, for example, in Furco, you had a broad general venue statute and a narrow patent-specific venue statute. And the Supreme Court said, well, if you could apply the general venue statute in a patent case, there would be no point to the patent-specific venue statute. But again, neither of those is present here. There's nothing that creates conflict, nothing that creates superfluity about the FDA's interpretation, which gives full meaning to the exclusionary clauses, which reads the exclusionary clauses to mean, if you work through chemical action or metabolization, you cannot be a device, therefore you can only be regulated as a drug, and which doesn't, create conflict
If you
either.
operated through, I'm a little bit confused by that. If you operated through metabolization, for example, you could be a non-drug, you could be a food.
You could, but you certainly, if you otherwise satisfy the device definition, you would be a drug. So if something satisfies the device definition, the other parts of the device definition, but achieves its primary intended purposes through chemical action within or on the body or metabolization, then it is a drug. It may also be other things, as Your Honor has noted, but it is a drug, because the drug definition fully encompasses the device definition. In other words, it's a drug regardless of whether it satisfies the exclusionary clauses. But if it satisfies the exclusionary clauses, it can only
not
be
a device
treated
and
as
it's a
not
drug.
a device and it's a drug. Exactly.
It ultimately decides the question that you say the FDA otherwise has full discretion over. So the only non-discretionary sorting as between the category of drugs and devices is that which is accomplished by the exclusionary clauses.
That's right. And I do want to make sure I spell out fully what the FDA regards as the limits on its discretion. So it's not just that FDA could not take all products satisfying the device definition and decide to treat them as drugs. I think it's worth appreciating for a second all the sort of rest of the regulatory framework of the device definition. So, to read Genus's brief, you might think FDA could decide tomorrow it's going to decide to regulate all Band-Aids as drugs and not devices. But there are, in fact, some 2,000 provisions in the Code of Federal Regulations that specify that particular categories of products are to be treated as class 1, 2, or 3 devices. The FDA couldn't change any of that without going through notice and comment rulemaking. So again, really, the authority the FDA is asserting here is extremely limited.
But under your view of the statute, you could change those regulations.
There would have to be a non-arbitrary or capricious reason for doing so that did not undermine the broader two-track scheme. I think if FDA exercised its authority in any of the extremely broad ways that have been posited, it would violate the statutory scheme. What it is doing here is exercising the authority as to a limited category of products where there are good reasons consistent with the statutory scheme for treating the category of products entirely as drugs.
You could make a plausible argument in any case you want that the article satisfies the definition of drugs. Drug regulation is more stringent. You rightly care a great deal about safety and efficacy, and you think it's important to have more stringent rather than less stringent regulation for some category of thing about which you have concern.
I respectfully, Your Honor, I don't think that would be consistent with the statutory scheme. Congress didn't create these as more and less stringent realms, and if FDA were to reason in that way, I think that would be contrary to the statute.
What is the limiting principle? You've taken off the table the one that Judge Henderson offered you, but what is the limiting principle in terms of the extent of your authority to reclassify or to categorize within that smaller circle?
The limiting principle is that the presumption is that something satisfying the device definition is treated as a device. And if FDA wants to regulate a product satisfying the device definition as a drug, it has to have a particular reason for doing so.
I'm
that is
sorry,
not
the
arbitrary.
Presumption in the statute, or just how you choose to exercise discretion?
The presumption in agency practice, which I think follows from the statute. And so if FDA is going to override that presumption, it needs to have
If it follows from the statute, that just sounds like an elliptical way of saying that the reticulated scheme associated with the narrower category is exclusive for the range of things to which it applies.
No, Your Honor, I think it's a way of saying that Congress's decision to create a separate scheme for devices suggests that as a general matter, something satisfying a device definition should be treated as a device, or else, again, if the FDA treated all devices as drugs, it would override the two-track pathway.
So, Mr. Winnick, I think this is what's difficult for me, is that it feels like you're at one time reading all the more specific definitions in the lead-in phrase as if they really just reduced to article. But then you're circling back, and that's sort of for purposes of like your jurisdiction over, which track, your authority to assign them to one track or another. But then it seems like you're sort of bringing back in those more specific terms as a guide for your discretion. In other words, could you take crutches, which are, an implement, and say, well, they're a drug because they're an article and they're meant to be, curative or, help people in getting over malady? Or can we take X-ray machine and regulate it as a drug? And, at some level, oh, well, it's an article. But so is that right, that you're sort of on the one hand rejecting that initial language, on the other hand, finding it to still have a bearing on your discretion?
So, Your Honor, the reason crutches, or to use my prior example, Band-Aids, couldn't willy-nilly be regulated as a drug is not, I think, that it is a thing that goes clank. It's that there is a regulation in the Code of Federal Regulations that specifies that those things are devices.
Nothing about the statute. Nothing. So those terms about, that are really resonate with common sense about devices should just be taken out. They're a leftover of another time. Instrument, apparatus, implement, machine, contrivance, implant, in vitro reagent, or other similar or related article, including any component, part, or accessory. I mean, Congress spent a lot of time figuring out how to write that, how to write it in a broad way to encompass a lot of things that don't seem to go clank, like maybe an in vitro reagent, and they could have just stopped and said article.
So let me try to explain why I'm resisting it, because I realize I am, and I realize sort of why the court might be inclined to read that phrase differently. There's a couple of reasons. The first is, if you look at page JA 332, this is the part of the FDA's guidance that talks about that phrase, about similar or related article, and explains why there's just a lot of products that naturally that ought to be regulated as devices and that aren't sensibly regulated as drugs, that don't obviously fall within one of those headings in the prefatory clause. So, for example, it talks about gels or powders that are used on the skin as a barrier, or gases used as space fillers, or, as I mentioned earlier, liquids used to clean surgical instruments. The other reason is that there are consequences to being able to call something a drug that have to do with parts of the statutory scheme other than the one we're talking about today. So, to give an example, if someone tomorrow tried to introduce a little metal box with the claim that it cures cancer, and the FDA wanted to prevent that obviously fraudulent device from being sold to the American public, the typical way in which the FDA would do that under its regulatory authorities is to say that because the claim is that the box cures cancer, it is a drug, and that therefore selling it without authorization violates the unapproved new drug provision of the statute. And so reading the drug definition as narrowed by the specific examples in the prefatory clause of the device definition has implications beyond the context of this case that are troubling to the agency, and I think for good reason. The other thing I just want to make sure I have the opportunity to mention is, even if the court is sort of concerned about the implications of FDA's interpretation across all categories of products, there's a very good rationale for deciding this case in FDA's favor, specifically with respect to contrast agents, which is that in the 2017 amendments to the statute, Congress legislated in a way that pretty clearly accepted as permissible the FDA's then 20-year-old policy of treating all contrast agents as drugs, which is that there was a problem called to Congress's attention by the FDA, that there was a lack of specific authority to approve a device designed to use a contrast agent in a manner different from the one in the agent's drug labeling. Congress could have dealt with that problem by telling the FDA to stop treating all contrast agents as drugs, but instead it did the opposite. It wrote the statute in a way that allows FDA to treat the product as drugs, but creates a pathway for approval of the device as a device. And that's a pretty good indication, as this court has recognized in many cases, that Congress approved the FDA's interpretation as permissible. So even if the court is disinclined to reach the broader question whether FDA can exercise this authority as to other categories of products, it should at the very least reverse the district court's decision as to contrast agents. And again, this was in the FDA's ruling letter as well, this rationale.
And tell me about the United States Pharmacopoeia and the National Formulary, and what role their characterization of, for example, contrast agents as drugs plays, if any.
So I may be misunderstanding, but I don't think there is any import to any characterization of contrast agents as drugs by those entities. The relevance of the 2017 amendments is not simply that they characterize contrast agents as drugs for the purpose of applying that sort of particular framework for approval created by the 2017 amendments. It's that Congress chose in 2017 to address this problem in a way that accommodated FDA's decision to treat contrast agents as drugs, rather than simply telling FDA, don't do that anymore, which it could easily have done.
Right, although it may be that those with an interest in this issue simply weren't at the table.
Well, I don't think that's accurate, Your Honor, because again, Congress wasn't doing this in the vacuum. It was, and this is clear from the committee report we cite, it was addressing this problem in close coordination with the FDA, because FDA had called this problem to Congress's attention. So I think it's pretty improbable that when Congress wrote those provisions in 2017, it didn't know that FDA had for 20 years been treating all contrast agents as drugs. That was the thing that created the problem. At least as to contrast agents that also, satisfied the device definition and could have been regulated as devices.
All right. Do my colleagues have any more questions?
All set, thank you.
Thank you.
All right, we'll hear from Mr. Farquhar then. And we'll give you a couple minutes, Mr. Winnick, in reply.
Thank you, Your Honor.
Thank you, and good morning, Judge Henderson. Good morning, Judge Pillard and Judge Katsas. Doug Farquhar, representing the appellee, Genus Medical Technologies. May it please the court. I'd like to begin actually by addressing the question that Judge Henderson started with, which is how can this medical product be a device? And it will also answer, I think, some of Judge Pillard's concerns about whether something could be a food or a cosmetic and a drug. There is a threshold determination that is made using the intended use portion of the medical device definition and of the drug definition, that if the product is intended to be used, in this case, for the assistance in the diagnosis of a disease, it is a medical product. So if a product is intended to be used not to treat a disease, it can be a food. But if it's intended to be used to diagnose, treat, cure a disease or prevent a disease, then it's a drug. And a drug or a medical device, depending on the second step of the analysis. all biologics are drugs. So there's no separation between those. Biologics are a subset of drugs, and that's made clear in the statute and in the regulations. The second step of the process, once a product has been determined to be a medical product, is it a drug or is it a device? The device definition, as Judge Katsas was explaining and explicating, is very, very clear. It is a device if it does not achieve its primary intended purposes through chemical action in or on the body or through metabolic action. If it does achieve its primary intended purposes through metabolic action or through chemical action, it is a drug. That's what's left. There's a universe of medical products. Some are devices, and those that are not devices are drugs. That's the way.
That's the way the statute read before 1990, but Congress got rid of the exclusion from the drug definition of everything that's a device. And I understand that the immediate task there was to open the way for combination products, but that clearly could have been done in a way that excluded devices that are not combination products.
Well, Your Honor, it's more than part. The FDA characterized that as being part of the reason that clause was excluded. But if you read the legislative history on that point, it is quite clear in the legislative history, first of all, that Congress viewed this as being a slight alteration in the definition of drug. That is in the Senate report. I can give you the site if you'd like, but the Senate report on the drug. It is just before the first time that Congress says this is a slight alteration of the drug device, which is intended to permit combination products, and combination products have a component of a drug or a device, to be regulated as a drug if the primary mode of action is that of a drug. That is, it achieves its primary intended purposes through chemical or metabolic activity. But
it seems puzzling why Congress would have removed that definition. I mean, you've reminded me that because the choice as between the device track and the drug track is determined by primary mode, why is that exclusion even needed if there's a third category that Congress creates and says, if it's combination, we don't automatically include it in device just because it meets that definition, nor do we automatically include it in drug because it meets that definition. Instead, we call an FDA to determine its primary mode. No need to take away the limitation on drugs to those that operate through chemical or metabolic functions.
Your Honor, the language that was removed from the drug definition in 1990 by the Safe Medical Devices Act had been in the statute since 1938. At that point, it was unclear until 1976, after the Bacto Unidisc case. It was unclear exactly where the line was drawn between drugs and devices. Quite explicitly, the original Medical Device Act in 1976 quite explicitly said we need to, as Congress, we need to set up a clear line between drugs and devices. They left in that earlier language, but it really almost became surplusage because they said, here's the fence. If you're chemical action, metabolic action, you're a drug. If you don't achieve your primary intended purposes through that mode of action, you are a device. So the language.
But Mr. Farquhar, the first paragraph of the MDA has the language that you seem to think doesn't have to be complied with. That is, the instrument, apparatus, implement, machine. What purpose does that serve? Just to try to describe without being exhaustive some of the more common devices?
Your Honor, originally when that language was in the statute, that was the only definition of what a device is. And I did want to address very specifically your point, Judge Henderson, about how could this product be a device. And I would turn to, first of all, the FDA in its current language, the language that's in the briefs, talk about how it appears to meet the definition of a device.
Right.
In the district court, the FDA actually admitted that it does fall within the definition of a device. It's at in the joint appendix, let's see, I'm trying to find it, it's 77 and joint appendix 104. But even if you go further back, if you go into the citizen petition response in 1997, that was part of the administrative record, the FDA actually addressed this very specific point with regard to ultrasound agents, because Judge Henderson, one of the parties in that matter, put into their citizen petition, how could a contrast agent possibly be a device? And FDA, correctly in our view, said it is because it is an accessory to a diagnostic procedure, it is a device. Barium sulfate, like those ultrasound products, is an accessory to the diagnostic procedure of taking X-rays or CT scans. Now, to get back to your question now, why is that language there? The language is vestigial, but it is quite broad. If you read it, yes, it talks about device contrivance, so on and so forth, but it also talks about similar or related articles. Article is actually the same way that drugs are described. They're articles. Right. So it's really what the distinction is. Once you have a medical product, in other words, once the use is intended to treat, diagnose, cure disease, it is a medical product, and then the distinction is either does it achieve its principal intended purpose, primary intended purposes through chemical action, it's a drug. If not, it's a device. And if I could, Mr. Winnick actually, I don't think he did this on purpose, but he said FDA could switch what's a device and what's not through regulation. That's not true. If you look at 21 USC 360C, it specifically says medical devices will be class 1, 2, or 3. And these are how we make the decision, you make the decision, FDA, as to whether it's class 1, 2, or 3. Well, Mr. Winnick might not say, well, that doesn't say all medical devices, but if you look back at the legislative history of the Medical Device Act in 1976 that resulted in this classification system for medical devices, the legislative history, as Judge Boasberg said, says all medical devices fit into one of these three classes. So you can't excuse a medical device from the class by regulation. The statute says if it's a medical device, which it makes perfect sense, is because it's a medical device, because it meets the definition of a medical device, has to be classed in this particular manner. So,
my understanding of FDA's response to that is once they choose to treat it as the statute permits them to, as a drug, then it no longer has to fit into 1, 2, or 3. It becomes a drug and only a drug.
That's correct. I wanted to make sure, though, that it was clear that it's the statute that requires it. What FDA claims is we have the discretion to regulate, to classify and regulate a medical product as a drug because it meets the intended use portion of the of both of the definitions, the drug and device definition. But I want to turn now to the reasons that they don't have that discretion. First of all, they can point to nothing in the statute that says, where Congress said we want FDA to have that discretion. The only thing that they point to is the removal of the clause, but does not include devices or their components, accessories, parts, etc.
It's a pretty big deal.
But on its face, it seems like a pretty big deal, but they did not touch the structure of the definition of what a device is or how a device is required to be regulated and classified. Also, so if it's ambiguous about what they intended by that, you're permitted to look at the legislative history. And the legislative history discusses this particular change in two different places in the legislative history. Both times it says it is intended to permit combination products to be regulated as drugs under appropriate circumstances. Combination products, it's focused on combination products. And our product is not a combination product. Then also, they say just before that point in the legislative history, this is a slight alteration. It would make no sense for FDA to make such a massive change in a scheme, a dual regulatory scheme, as Judge Boasberg described it, that is so important that in 1976, the Congress set forth these very specific rules about how you have to define medical devices and how you have to classify. Now, Mr. Winnick talked about the Radlax case, and he again misrepresented the holding in Radlax and the language in Radlax. In the final brief that FDA filed, it said the narrow versus general or specific versus general canon is restricted to these particular circumstances. That's actually not what Radlax said. What Radlax said, what Judge Scalia said in that decision is, it is perhaps most frequently applied in those kinds of situations. But if you look at the other language in Radlax, it fits quite specifically the situation we have here in terms of narrow versus specific. In particular, it quotes the Chase decision from 1890. And even in 1890, this is what the Supreme Court said about it. It is an old and familiar rule that where there is in the same statute a particular enactment and a general one, which in the most comprehensive sense would include what is embraced in the former, the particular enactment must be operative. This language is still valid. It was recently cited, I think it was in the Eagle case, if I remember right, or in the Adirondack case. It is still operated that when, especially when, and this is what Judge Scalia said and what has been repeated in more recent cases, where, especially in the same enactment, here, G, subsection H1, same enactment, right next to each other, where there is a specific definition or a specific provision, and then there's a general provision, when the conduct at issue falls within the scope of both provisions, the specific presumptively governs whether or not the specific provision also applies to some conduct that falls outside the general. So it's clear that the narrow or specific versus general canon is not restricted to the circumstances that Mr. Winnick has argued. I would like to go back to in terms of the device definition and why it is such a it's such a clear line that's drawn by the statute. This a line that still remains, and the reason is because, as I say, it's a universe of products that are medical products. Medical devices are specifically defined. What is not a medical device by default is a drug. Makes perfect sense. It's implicit. But as was held in the Eagle decision, implicit, if I can say, just quote that case, if the text clearly requires a particular outcome, then the mere fact that it does so implicitly rather than expressly does not mean that it is silent in the Chevron sense. I see my time is up. I did want to mention just a couple of other things, if I might, Your Honors.
Go ahead.
Thank you, Judge Henderson. One of the things that you may need to get to if you don't believe that this case is resolvable on Chevron step 1 is whether the decision that Mr. Winnick is advocating for here, the decision that our product can be regulated as a drug, was an arbitrary and capricious decision. And I would like to point out that that decision relies on two cases, and two cases alone, for the proposition that FDA has discretion to characterize or classify a device as a drug. One of those was the Coin against Beam case, which was overruled in Brown against Williamson. The other case is the Bracco decision that came out of the district court. But that response to the citizen petitions, as well as the government's view of that case now, distorts what the holding in that case actually was. Of course, it wouldn't be controlling on this court anyway. But what the holding in that case was, there were two holdings, really. The first is you have to treat similar products in a similar fashion. That is a holding I've actually argued on. It's a correct holding. I've cited that case many times for that proposition. But then what it said is these appear similar to me, Judge Friedman said. It is likely that FDA has the discretion to regulate these products either as a drug or device. And that is not a decision, it's likely. What he actually decided was, and instructed FDA to do, was either treat these products the same or explain, give me the reason why you're not treating them the same. So it's not the holding that there was this discretion. I don't think any court has ever recognized that there's discretion for FDA to classify a product that meets the definition of a device as a drug. And it would be contrary to the structure, the text, the purpose, and the history of the statute. I'd be happy to answer any other questions.
I have a question on H1, and how is a device recognized in either the formulary or the pharmacopoeia? What does the recognition involve?
Yes, Your Honor. I will try to answer that. There actually is, the United States Pharmacopoeia historically is a non-governmental institution that has monographs for particular drugs and particular devices. And what FDA has, or what the statute has said, and this is because this has been historically in the statute forever.
Right.
Because back in 1938, the U.S. Pharmacopoeia and the National Formulary, which is part of USP, were the Bible in terms of what was a drug and what was a device, and whether it had to meet these particular requirements and specifications in order to qualify for listing in the USP or for using the USP label. These products, that is not an issue here. This particular product, barium sulfate, used as a contrast agent for radiological health, would be, in fact, superseded by the statutory definition anyway. But I'm confident that if it had been listed in USP as one or the other, one of the parties who's before you would have recognized that and brought it to your attention.
So is it recognized or not?
I'm not sure, Your Honor. I don't know the answer to that question.
Well, but it's supposed to be.
No, Your Honor, I'm sorry. It's
or
an
is it?
It's an
it's an alternative. Well, now wait a minute. It says 1, recognized, or 2, intended for use, or intended to affect. So how do you read the or comes after H2?
That's correct, but it's if you look at the way that the statute is indented and so forth, and I'm looking at the version that's in the government's original.
Right. So my A1.
The way it's indented, it's 1, 2, or 3. In other words, you don't have to put the or after 1.
I see. Okay. Thank you. Any more questions? All right. Mr. Winnick, why don't you take 2 minutes? Oh, go ahead. Judge Pillard.
I think you answered this, Mr. Farquhar, but I just wanted to confirm it. I heard Mr. Winnick to say that he's not attracted to the suggestion that the prefatory language that you described as somewhat vestigial is actually playing any role in distinguishing devices from drugs. And I thought I heard you to say more or less the same thing.
That's correct.
You wouldn't see that as operative in addition to, in your view, or in contradistinction to, in Mr. Winnick's view, the metabolic and or chemical action exclusion, you both think that the lead-in language doesn't really play an operative role anymore.
I'm glad you asked that question, Your Honor. And if I might give just a couple of examples, I think it would help the court understand. We both agree that that language in terms of articles in the drug definition and instrument, apparatus, implement, machine, contrivance, implant, blah, 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 is very, very broad language. It is the intended use of the product that makes it a medical product, and it is the chemical action that we contend, in this case, makes it a device. Now, it seems sort of counterintuitive that something that you swallow would not be a drug. And that's precisely why this explanation or why this definition is in here on chemical action, setting up the fence. So for example, we mentioned in our brief, there is a device that you swallow that is an alternative to a colonoscopy that passes through your system and takes pictures of your GI tract as it's working its way through. The fact that our product is swallowed, the fact that it's liquid, does not make it necessarily a drug. It is a device because it is not achieving its primary intended purposes through chemical action within or on the body of man or being metabolized. It is inert. It does not chemically interact with anything. It passes through your system. It's excreted. If I might take just a quick second, my daughter is a pediatrician, and I was talking to her about this argument the other day, and she said, oh, we just used barium sulfate today. We had a child, they wanted to check motility in the child's digestive tract, so they gave the child scrambled eggs with barium sulfate in it, and then they watched through the x-ray as it passes through the system. So that's not a drug-like effect. That is a device-like effect, showing, as it goes through the tissue, showing whether there's deformities in the tissue and showing how it tracks through the system. I appreciate your allowing me to divert into that little anecdote.
I don't see why it isn't a drug-like effect if both of them are used for diagnosis. Barium sulfate, what you just described, was diagnostic.
That's correct, and devices specifically,
which is what a drug
no,
has
Your
to
Honor.
be.
No, Your Honor. I would disagree with that because it is, if you look at the number 2, it's intended for use in the diagnosis of disease or other conditions. This is, I'm sorry, H2 under device. Devices can be used and frequently are used, mostly are used probably, in terms of helping to diagnose diseases. But
And in fact, the same term about diagnosis applies in both the drug and device definitions. Yeah, that's right. The more fundamental.
Right. That's what I was saying. Was
I'm sorry.
Just because it's diagnostic doesn't mean it's not a drug.
That's correct. It's the fact that it does not achieve its primary intended purposes through chemical action.
Right.
Thank you very much.
Which relies on the exclusionary clause, which isn't included in the definition of drug, but okay.
That's right. But again, the corollary of that clause is that the things that do achieve chemical action, their primary intended purposes through chemical action, and that are medical products, they are drugs. That's what's left. Thank you. We would ask that you affirm the district court decision.
All right, Mr. Winnick.
Thank you, Your Honor. 5 points, which I promise are quick. First, as I noted at the beginning, Chevron deference applies under Milan. So the FDA wins unless its interpretation is unambiguously foreclosed or unreasonable, and it's neither of those things.
But second, I thought you relied only on clear language and didn't rely on any exercise of discretion in this case.
So we think the FDA properly exercises its discretion to treat this product as a drug. We think
but in the reading of the statute, you think it's clear?
We think the statute leaves it open to the FDA to treat products satisfying the device definition as drugs, that Congress hasn't clearly required the FDA to do otherwise. Second, as to RADLAX, we don't mischaracterize that decision. The decision says the canon is most frequently applied to avoid a contradiction, but it is also properly applied to avoid superfluity. Our point is that there is neither a contradiction nor superfluity. Third, the question before the court isn't what Congress had in mind in 1990. The question is whether there is a basis to read into the text of the drug definition a limitation that isn't in its text. And the relevance of what happened in 1990 is simply that it would be all the more incorrect to do that where Congress expressly removed the limitation 30 years ago.
I think
Fourth,
the proof. Oh, go ahead.
No,
Get your
I'm
five
sorry,
out,
Anna.
and I'll ask you the question. I'll
Okay.
remember it.
Fourth, aside, even if this court weren't to rule on a basis specific to contrast agents under the 2017 amendments, it should have no concern that if the FDA were in the future to apply the authority it's claiming here more broadly than it has done in 30 years, that the court won't be able to confront that. Manufacturers can easily bring APA challenges to any future decisions that go beyond the narrow terms the FDA is defending today. Finally, I don't think it's open under Chenery to decide for the court to decide this case based on the prefatory clause, but the FDA would regard that as highly disruptive to its regulatory authorities. So to sum up, the district court's decision is wrong because it reads into the statute exactly the language Congress removed 30 years ago without any compelling rationale in the statutory structure or purpose, and in a way that upsets 23 years of settled industry expectations. I'm sorry, Judge Pillard.
I said I would remember. You said there's no concern here about superfluity, but I think the questioning that you heard from the bench in your argument in chief was, why is your reading not rendering the device definition superfluous insofar as everything that's a device is also a drug?
And our answer is that the FDA might do that if it were just deciding to treat every device as a drug, but it's not doing that or even close, and it's not asserting the authority to do that. What it's asserting the authority.
Right. I guess the question is, what's the frame for superfluity? Is it in the scheme that Congress is mapping, or is it in the world as the FDA exercises its power? And I thought that it was the former, that the superfluity should be identifiable from just reading the statute without knowing how the FDA is going to act. But maybe your view is, no, we have an option, and so it's not superfluous because it's giving us an option.
Yeah, I think superfluity is a fairly formal analysis. It is the language in the statute given full effect. And our point is that the exclusionary clauses of the device definition and the device definition as a whole is given full effect in FDA's interpretation because it specifies what the FDA cannot regulate as a device. If something falls within the exclusionary clauses, it must be regulated as a drug and not a device.
And what's your best answer to Mr. Farquhar's point that this was something that Congress thought of as a small change? And indeed, if it had intended to throw a lot of discretion into FDA's court, wouldn't you expect that there would be some discussion of what guides that discretion?
So I think a few points. One, it has been a relatively small change. Again, this hasn't come to the court in 30 years because the FDA asserts this authority very rarely. Second, Congress did put in the statute a means for the FDA to exercise discretion in classifying products as to which it's unclear whether they should be treated as drugs or devices. That's section 360 BBB2. And third, I find it instructive to sort of pretend for a second that 1990 had never happened, pretend the statute had always read exactly as it does today. In that world, it would be just as true as in this world that it would be improper to read into the drug definition a limitation that isn't supplied by its text. So the only additional point that 1990 gets us is that it would be even more unwarranted to do that where Congress removed the same limitation when it was expressed in the statute. So, to all of Mr. Farquhar's points about what the legislative history does or doesn't suggest, even if you think, Congress might not have meant to do this, the only effect that would have is that you put less weight on that additional reason we win. It doesn't go to any of our more fundamental points about the impropriety of reading into the drug definition a limitation that simply isn't in its text and that is not necessarily implied by the structure or purpose of the statute.
You mentioned that I do find it notable that it's been 30 years and this is the first time this issue has come before us. It makes it seem like it isn't a dramatic change. But then when you say the FDA asserts this authority very rarely, I almost find that to be an incomprehensible sentence in view of the way you read the authority, because every time it regulates a device as a device, it exercises this authority in your view.
Well, except that
because
in practical terms,
there's no statutory meaningful distinction other than the biochemical or the chemical and metabolic carve out.
So the way I see it, Your Honor, is this. From Mr. Farquhar's telling, you would think that every time a manufacturer goes to create a new product, a Band-Aid or a crutch or whatever else, they are, sitting there in a state of uncertainty about what FDA is going to do. But the reality is that for the overwhelming majority of products, it is specified in the CFR what device class the product falls into if it's a device. So the authority the FDA is defending comes into play only in a narrow, limited number of cases where there's not some regulation on point, where as a historical matter, there's been some ambiguity in how the product is to be treated. We've identified sunscreens, contrast agents is one, but this is not some large list of things. And even as to products in this category, again, it's I think rings hollow to suggest that even contrast agent manufacturers, are sort of hurt by some uncertainty about this. When, as this Gisket amicus brief points out, it's been perfectly clear to contrast agent manufacturers since 1997 how they were going to be regulated. And what Genus is seeking here is an exception to that consistent, longstanding, and perfectly clear policy, which, for the reasons we argue, is sensible and should be upheld. For those.
And you resist the. So I had thought that that there was a distinction between what's included in the device definition, which distinguishes it from the drug definition in terms of machines and implements, versus what's excluded from the device definition, which isn't necessarily included in the drug definition. But I think I had been operating under what may be an incorrect view of a multipolar FDA regulatory regime, that something could be a drug or a biological. But now that I've been corrected that all biologicals are drugs, and where you're talking about a cosmetic, the statute's explicit about how to deal with the overlap. And in fact, so if something that's excluded from the device definition isn't thereby defined as a drug, why not, as a practical matter? Does that make sense? I know that's a little bit of a jumbled question.
No, that's right. I mean, so I think if you were to regard the device definition in the abstract, the thing that makes it a drug is not that it is excluded from the device definition. The thing that makes it a drug is it falls in the drug definition.
Right.
And whereas it might otherwise overlap with the device definition, there is no such overlap if it's in the exclusionary clauses. Does that make any sense?
Yeah, but doesn't that just reinforce the district court's reasoning?
I may not.
No, you're saying no because everything that's in the device definition is in the drug definition, and therefore the fact that it is not excluded doesn't mean it is exclusively a device, right?
Yeah, that's right. I mean, the core of the district court's reasoning, if you boil it down, is Congress could only have intended for these to be mutually exclusive categories. They have to be mutually exclusive categories. And our point is that's not right. It's certainly true that if FDA treated every device as a drug, it would eviscerate the two-track scheme, and that would be impermissible. But there's nothing at all inconsistent with the statute, or frankly unusual in the context of the FDCA, for the FDA occasionally to decide that something that satisfies both definitions should be treated under one track or the other.
Can I just try one more time? Tell me, what is the legal principle in the statute that limits your asserted power to reclassify such that you could not treat every device as a drug in the statute?
the FDA has to have a good reason for treating as a drug a product satisfying the device definition, and it has to be consistent with the statutory scheme. And it would be inconsistent with the statutory scheme if the FDA exercised that authority as to every product satisfying the definition of a device, because as Your Honor has noted, Congress clearly envisioned that there would be two distinct tracks. And if any manufacturer in a future case thinks that FDA has exercised that authority impermissibly, it can easily bring an APA challenge, and this court can, set limits on the FDA's discretion.
Thank you.
All right. Your case is submitted. Thank you.
Thank you, Your Honor.
Thank you.
This honorable court is now adjourned until Monday, December 14th at 9:30 a.m.